In today's video, we're going to look at the very final comments in the court case involving Lucy Letby of Judge James Goss. These were literally the last things that the jury heard before they retired to make their decision. In today's video, the comments of Judge Goss begin with the following, these concluding comments, I should say. I return to where I began and refer you to my legal directions 1, but I will not go through them again, and I've asked you to put them with the indictment for your assistance. You have there set out in legal directions 1 what you must do and not do, and what you have to read conclusions upon, the importance of reaching decisions on all the evidence and determining, in relation to each alleged offence, whether you are sure of the defendant's guilt or not. You also have my legal directions 2, in relation to the evidential matters, including the defendant's character, inconsistencies between her evidence and her defence statement. So this is the first point where we can comment. The first statements here are largely just directions to the jury. So this notion that there are inconsistencies between the evidence of Lucy Letby and her defence statement, this is all really based on this bombardment of comments from Nick Johnson in which they try to pick out the most arcane or trivial things possible, often, as we know, using fabrication and invention, and then try to make out as if this is somehow damning, when we're talking about events that happened 6-7 years previous to this, that no one can be completely conclusive about. Is simply impossible because we're relying on memory. So a lot of the nonsense we've gone over is just simply the prosecuting barrister trying to say, oh look, there's an inconsistency, oh look, Lucy's deliberately misled the court or deliberately given an inaccurate statement. And as we know, a lot of that is on incredibly trivial stuff or stuff that isn't even relevant at all. And often it's not proven, often it's based on, as I say, fabrication, supposition, etc. But you notice here in this final summing up statement that it's just being provided as a matter of fact. So the judge goes on to say, inconsistencies in the evidence of any witness, the effect of delay and expert evidence. So I suppose you could argue that here Judge Goss is at least introducing the possibility that witnesses may have given inconsistent statements. However, he specifically points to inconsistencies with Lucy between her evidence and her defence statement, whereas in regard to the witnesses, this just passes by without any specifics, or despite the extraordinary cross-examination of Dr. Evans, we will see in these final summing up statements, there's no reference to anything that he said. And I'll reflect on that at the end of the video. You have to consider the evidence relating to the collapse of each child, their condition in the period leading up to the events, the nature of the collapse, its features and consequences as described by witnesses, as well as what the defendant has said and done, be it in messaging or in person, before, during and after any event. So we're just going to look at the collapses because this is critical here. So you see the judge says you have to consider the evidence relating to the collapse of each child, their condition in the period leading up to the events. So we know that the jury heard a very misleading impression of the state of those children and what occurred around the collapses and whether or not they were well or unwell. And they were always told that these were very sudden collapses of infants that wouldn't be expected to collapse, that weren't suffering with any difficulties. So I'm just going to go over this very briefly with regard to a few of the infants in the case. So we're just going to look at the instances in the court case of children being described as doing very well. Of course, there are many other descriptions, what I would describe as misleading descriptions of the wellness or otherwise of children. But we're just going to look at the phrase very well. So here we see child A being described as having died despite doing very well. So child A was suffering from an absolute catalogue of problems. The breathing rate of this infant was abnormal throughout the 24 hours preceding his collapse. The increased respiratory rate of child A indicated possible respiratory distress syndrome. This condition requires treatment with surfactant therapy, but the infant never received this. Child A also had an increased lactate level associated with a higher likelihood of morbidity and mortality. This infant also went at least 4 hours without IV fluids, receiving just 2 millilitres of breast milk during this period, and was under a heat lamp while attempting to get IV line access. This extended period of time under the heat and without fluids increases the risk of fluid deficit, which can cause electrolyte disturbances that affect the brain and heart. Skin discoloration and a rash was noted in the case of child A. This can be indicative of a cardiorespiratory event, a sign of blood seeping away from the surface of the skin to the organs. During the treatment of child A, his long line was considered too deep by both the doctor who placed it and the consulting radiologist, but this was never corrected. Collectively, this strongly indicates suboptimal care, which was conceded in other cases, and serious questions about stability. Of course, when we heard from the so-called expert witnesses with regard to child A, they conveyed almost none of this or downplayed it. I should also mention that in my video with Dr. Martin Pittman, we talked about the obstetric picture of both child A and child B not being conveyed properly to the court, or indeed conveyed whatsoever. So I'm not going to go through the similar descriptions for the other children, but with regard to child C, Dr. Bohin says that the infant managed very well indeed in his early days. Of course, we know, again, with child C, it's absolutely ridiculous. The child is clearly suffering with a bowel obstruction. It's blatantly obvious. To say that this child was very well is absolutely ridiculous. Child G, another child that was really, really struggling. So it's notable as well. We're talking about infants here that were very premature and very unwell. So this child was progressing very well for a preterm baby. Child I was tolerating feeds very well. Another child that was chronically ill. Child I had normal gases and improved very well. Child I was observed to tolerate a peripheral line very well. Child J was described as progressing very well. We should say this is an infant for which Lucy Letby was found not guilty. Child N was progressing very well. This is the child, one day I'll go through the full details of this. I've done one video on child N just explaining how ridiculous the whole circumstances were, and what was said in court in relation to this child is utterly laughable. But apparently this child was progressing very well as well. Child O was very well. Another statement here to say that child O was progressing very well, despite the fact that the child was suffering from a subcapsular haematoma, and the pathologist cited the subcapsular haematoma as being the cause of death. Child B responded very well to resuscitation and breathing support measures, according to Dr. Evans. And then child P appeared very well, according to Dr. Gibbs. In today's video, So when Judge Goss says you have to consider the evidence relating to the collapse of each child, the condition in the period leading up to the events, the nature of the collapse, its features and consequences described by witnesses. The problem is that the jury heard a series of events and a series of accounts that were completely misleading. That is really the fundamental problem when people will argue and will assert that the jury heard all the evidence. They heard the evidence was presented in court. Firstly, that was not all of the evidence, and secondly, a lot of the so-called evidence that they heard was just simply misleading or incorrect. So they're not actually in any position to consider the evidence. Even if they were medically qualified, it would be very difficult. But given that they're not medically qualified, they're enormously reliant on expert witnesses, and they just heard an absolute litany of inaccurate information, then what they're being asked to do here by Judge Goss is effectively completely impossible. So Judge Goss continues to talk about what the defendant has said and done, be it in messaging or in person, before, during and after any event. So this was the text messaging that we saw in court, which has no relevance. There was nothing that could be cited that had any specific relevance to anything that occurred. Lucy's text messaging was, as the police stated, completely normal. There's nothing unusual about it, and efforts were made to try and characterise some of her behaviour as abnormal. It was described by Michelle Warden as weaponising normal or even healthy behaviour for nurses and saying that it's somehow sinister. That is sinister in itself, I would suggest. And then Judge Goss goes on to talk about Lucy's enthusiasm to be in Nursery 1. So firstly, I would say in relation to this that this is very much a matter of interpretation. What is described here as enthusiasm could instead perhaps more reasonably be described as professional a professional tendency. You would want to be in nursery 1 because you know that's where the sickest babies are being treated. Those are the babies that are in real danger. So it's your responsibility. It's a professional responsibility to be in that nursery. For that to be described as enthusiasm, possibly she was enthusiastic about her job. She was very passionate about it. Whether enthusiasm is quite the right way of describing it, I would doubt. I would say that she was very professional in everything she did. Everyone agrees on that who works on the unit. And she would just see it as her duty to be in nursery 1. So I think interpreting it as enthusiasm is very poorly founded to begin with. But let's have a look at what was said about nursery 1. In court, this is during the closing statement of Nick Johnston. We'll be dealing with this in the future. He says, Lucy Letby, we suggest, could not keep out of nursery 1. She elbowed her mate out the way. Obviously, this is a preposterous phrasing and just simply not what occurred at all. Obviously, Lucy was considered to be an experienced nurse on the unit, or a nurse that was highly regarded, and she was entrusted with some of the sicker infants. That's just a fact. That's in the Thirlwell inquiry. That is known to be the case. So the sickest infants are in nursery 1. So Lucy's probably been assigned to some of these infants. So she knows it's her responsibility to be there. So to say she's elbowed her mate out of the way, it just doesn't work like that. I mean, if Michelle was here now discussing this, I'm sure she'd talk about this for about 10 minutes about how stupid it is. Obviously, she's a lot more experienced than me, but I know in a hospital, you're assigned to a certain unit, you're requested to do something, and to say that it's inappropriate of Lucy to want to be and to want to do her duty of being in the nursery with the sickest babies, let alone characterising it as her elbowing someone out of the way, which is not even true, I think is ridiculous. It's just yet another fabrication. It would be impossible to make a list of all of the fabrications that occur and all of the suppositions that occur in this court case, because given that it could be 20 million words, there could literally be tens of thousands of incidents of fabrication in this court case. But this is just yet another one where Nick Johnston just says something that just clearly didn't happen. And of course, the whole assertion that Lucy was enthusiastic about being in this nursery is, to say the least, an interpretation in the first place. What is far more likely, as I said, was that she just simply needs to be in there because that's where there are sick infants, and she doesn't want an infant to pass away or experience discomfort or distress. It could far more legitimately be argued that if there was an emergency and if there were problems and she didn't want to go into nursery 1, that would be a bigger problem. So then we move on to my favourite part of the court case, which, as Judge James Goss describes it, is the taking and retention of hospital documents. So it's been a few days since I've had to discuss the handover sheet, so I'm glad that we're going on to this again. Now, you would think this will be the only time that he mentions the handover sheet in this relatively short passage of speech. Oh, no. He mentions them again before the end. So, I mean, I've been over the reasons why this is irrelevant and ridiculous so many times. It's staggering. It's staggering that so much could be made of something that has nothing to do with the indictment whatsoever. It's completely unrelated to the indictment, and yet here I am yet again discussing the handover sheets. So let me just mention firstly, to say that Lucy took the hospital documents, by which he means the handover sheets, is stretching the truth, is stretching reality, because it's very clear and very obvious that she didn't deliberately take them. She has no reason to do that. It doesn't benefit her in any way. Indeed, it's been mentioned over and over again in the court case. It's been mentioned over and over again ever since. No doubt I will still be discussing this on my deathbed. I'll be there in palliative care and they'll be saying, what about the handover sheets though, Chris? I know Lucy's been out of prison for decades, but what about the handover sheets? It's nothing to do with the case. Nothing. Absolutely nothing. And she obviously didn't take them home on purpose. Why would she? Why would she take them home on purpose? It doesn't serve any purpose whatsoever. What would she do with them when she took them home? In fact, we know what she would do with them. She'd stick them in a carrier bag under a bed and she'd stick them in a bin bag in the garage because they don't have any value. They don't even have any relevance a few days after the these days have passed. You know, there may be some relevance, like the next day when the case is being handed over. A couple of days later, they don't even have significant medical information. She obviously didn't keep them as trophies. That's crystal clear by the way that she stored them. The only reason she retained them is because she didn't want to take a massive bundle and chuck them in the confidential waste. It's as simple as that. Constantly referencing this over and over again is embarrassing. Let's move on to the irrelevant Facebook searches. Again, discussed this many times previously. It has nothing to do with the case. She barely searched for any of the parents on Facebook. She made thousands of searches for other people. It has nothing to do with the indictment whatsoever. It's completely irrelevant. And then, more reasonably, he talks here, Judge Goss, about what she said at various times of the investigation about what she has done. That's fair enough, of course. She was cross-examined, and it's reasonable to look at that, even though there were many problems with her cross-examination. And even though Lucy, I think, gave a very good account of herself, and you heard Dr. Jonathan Moore the other day saying that she was exceptional. Under a lot of pressure, with a very experienced barrister in a very difficult situation, in a scenario that most people accused of murder don't go into. As I mentioned, the American rapper P. Diddy, who was in court recently, he never said a single word during the court case. He wasn't called into the witness box, or the stand as they describe it in America. So she actually did very, very well, but it is reasonable for him to say that. Where there are conflicts in versions of events, words or actions that you consider significant, you have to decide whether resolution of those conflicts assists you in reaching conclusions in relation to the offence under consideration, and if they do, where that leads you. So I'll just say in relation to this that as the prosecution made up absolutely loads of stuff, it's very, very difficult for the jury to know whether or not it's reasonable or whether or not it does lead them anywhere, as is described here. I mean, ultimately, the prosecution put forward these versions of events. We've seen very recently, and I've discussed this in a previous video, it's discussed in my book as well, the version of events that the prosecution gave in relation to Child E, this is in a video that Jabe made recently, is just plain wrong. It's just very obviously wrong. I've discussed this recently in previous videos as well. But this is very, very difficult for the jury to say that definitively. Even if they could remember what was said, given the court case was dragged out for as long as possible. There was this dizzying array of labyrinthine information that the jury was bombarded with, and then they're supposed to look at, hey, if you saw any conflicts. Ridiculous. And then we go on to, if you were sure that two of the babies, baby F and baby L, had Actrapid manufactured insulin inserted into the infusion bags that were set up for them 8 months apart in August of 2015 and April 2016 respectively, and you were sure that was done deliberately. So I'll come on to the second half of this statement because we're just going to consider this briefly. In today's video, so the problem that the jury face here, aside from the fact that they were misled, aside from the fact that they were this deceptive argument of getting Lucy to agree that an infant had been poisoned by insulin because she was told by experts that it had been poisoned by insulin, so she then agreed with that statement. Leaving aside the fact that the jury were deliberately misled by this underhand and deceptive tactic, the other problem that they faced was that what they were told was entirely hypothetical. So the judge is saying, you need to be certain whether or not bags were deliberately poisoned, but no one can ever be certain of that. And they, intellectually, it seems that the jury were unable to understand this because they unanimously agreed that Lucy Letby had poisoned infants with insulin, when in fact, there's no way for them to know this because it was hypothetical. So there was no evidence provided, none whatsoever, that the feeding bags were spiked. It was just purely a hypothesis and theory from Professor Hindmarsh. Professor Hindmarsh, who was then later deregistered from the GMC. And as we know, the bags weren't retained. Lucy wasn't around for one of the supposed poisonings. She wasn't around to hang up the bag. She was off duty when it occurred. It was extremely unlikely, even before you look at the very specific facts. All the jury has been given is one measurement that we know to be erroneous, that we know to be unsatisfactory, that we know is an actual forensic measurement of exogenous insulin, and that's it. There's no other evidence whatsoever, none. And from that, they're supposed to extrapolate whether or not they can say beyond reasonable doubt that infants were poisoned with insulin. Now, if they'd intellectually understood the case, and if they'd known what was meant by reasonable doubt, and if indeed we still told juries that they need to be certain beyond reasonable doubt, then I'm pretty sure that Lucy would have walked free, because they would have known that there wasn't definitive evidence for any of this. But unfortunately, they were confused by the prosecution case, and then there wasn't satisfactory opposition to that prosecution case put in court. But there is no way for the jury to be certain. It's just absolutely impossible. So return to the comments of Judge James Goss. So he then goes on to say, having made this comment about whether or not you decide that this was done deliberately. I mean, they were so far misled on that topic. It really should be discussed further, but I think I've made it clear enough. But then he goes on to say, you then have to consider whether that may have been a coincidence, two different people independently acting in that way, or whether the acts of one person, and if so, who. So given that it's almost of all the preposterous statements made in this court case, that's got to be up there, because the jury was only ever given one option. No one else was ever presented as it being remotely possible that they could have acted in this way. And later in this summing up statement, Judge Goss is going to underline that himself. You have to be sure that the child whose case you were considering was a victim of an intentional harmful act or acts of the defendant, and if it was, what her intention was at the time. She, of course, denies she ever did anything wrong. So all I will say in relation to this is that I don't like this use of the word denies. I realise that may be common parlance in a courtroom, but perhaps they could use the word indicates or something neutral. It seems to me everything is stacked against the defendant, even language is stacked against the defendant, and everything is lined up favourably for the prosecution. There's no wonder that we have miscarriages of justice. And so anyway, it continues. Although you have to decide on the evidence in each child's case, there were certain common features as listed by Mr. Johnson. This is the first part of my first legal direction relating to circumstantial evidence and coincidence. So essentially what he's about to do here is just list all of the arguments that made by the prosecution. I began to go over some of those arguments in the most recent video of the relating to the closing speech and closing statement of Nick Johnson, in which he just says, oh look, this happened in relation to these infants, then this happened in relation to these infants. So here we see Judge Goss just listing all of these things as if this has credibility or relevance. So it begins here, just underlining. So here he immediately says, the defendant was on duty on every occasion an event occurred. So let's go back. He's just said here, you have to decide whether or not it's Lucy Letby or not, but we're giving you absolutely no choice. So he might as well have not even said that, really. And this is, again, inflating the importance of this shift chart that we know to be worthless. And then also, let me emphasise once again, we've seen people suggest, I mean, I think this argument now holds absolutely no water, not that it ever held any water in the first place, but we've seen people attempt to claim that the shift chart isn't an important feature in the court case, but in fact, in the very final comments, again, we've seen it on numerous occasions previously, but in these very final comments of the judge, when he's summing up the entire court case, he utilises the shift chart to make this very important argument. And as I've said numerous times, but I'll say it again, many inferences are made from this throughout the court case. When there is no evidence, and God knows that happens quite a lot, Nick Johnson will just say, of course, we know it could only be Lucy Letby because there's only Lucy Letby on duty. He said that countless times, and it was child A, B, C and D where they really established this argument, and then they just faxed, they literally like photocopied it and faxed it all the way through every other infant in the case. And that formed an absolutely critical pillar of the prosecution case, undeniably. So Judge James Goss continues. There were 10 babies who collapsed that had good entry into their lungs, but their saturations were dropping. Mr. Johnson gave you the lists and invited you to write them down. 5 of the babies, if you accept the evidence of mother and of babies E and F, had unusual bleeding, some in their throats, which was seen by medical staff. So I'll say a couple of things in relation to this. Firstly, in a few of the cases in court, the bleeding passed by very quickly and wasn't a major aspect of the court case, even according to the prosecution. So to say that these are all indelibly linked in some way is very poorly founded. The second thing that I'll say is that what you'll see for all of these cases, and it certainly applies here, is that he's saying, oh yeah, what an enormous coincidence, there's 5 infants for which this occurred. Well, that means there's 12 infants for which it didn't occur. In today's video, 8 of the babies demonstrated discoloration, which was seen by doctors in more than one baby and unique in all their experience. The defendant said that in many of the cases she either did not see the discoloration or that there was no discoloration to be seen. So of course I've been over the details of this many times previously. What we see in the court case as described here is simply doctors saying, I've never seen this before. But just because they've never seen it before doesn't mean there can't be an explanation for it. And of course, once very much more experienced doctors went through the clinical notes, they found the explanations. We can also say that this comment about 8 of the babies demonstrating discoloration is now completely irrelevant because it's all different types of discoloration that indicate a circulatory collapse. We know for a fact that this can just be thrown out the court case completely. 8 babies suffered unexpected life-threatening collapses. That's absolutely true. And then recovered very quickly, which was very unusual and could not be explained in medical terms. So that's according to Dr. Evans. Of course, we now know that these things can be explained. Another feature common to events concerning 5 babies is that they occurred within a few minutes of their designated nurse going on a break or leaving the room. So there's a few things to say about this. The first thing is that's not even properly established. This is based on the cockeyed circumstantial case that was put in the court case by the prosecution, a lot of which is just incorrect, or in some cases based on supposition. It's also based on useless and inaccurate data on many occasions. That's the first thing to say. The second thing to say is, even if this is true, we don't even know if this is true, but even if this is true, it can just simply be a coincidence. There doesn't have to be anything sinister about this. It can just be something that occurs. The third thing to say about this is, this only occurred with 5 of the 17 infants, so it didn't occur with 12 of the infants. So to attempt to infer or assert any sort of meaningful pattern with something that's only occurring in approximately 30% of the cases is pretty ridiculous and essentially meaningless. Anyone will tell you this has no statistical validity whatsoever. In baby P's third event, the defendant, who is his designated nurse, was in the room, but the doctors were out of the room. So what? So what? What the hell does that mean? Completely meaningless. As I have just reminded you, when baby Q collapsed, the defendant had just gone to another nursery. Meaningless. Completely meaningless. I mean, it's just in 1 infant out of 17. This could happen to anyone at any time, in any hospital, anywhere in the world. 4 of the premature babies were heard to be screaming or crying uncharacteristically at the time of their collapse. So firstly, this is again debatable because the confirmatory evidence that points to this is not of an acceptable standard. For some of the infants, this involves parents, and it's highly debatable whether it's uncharacteristic at the time of their collapse. This simply hasn't been established to anything like an acceptable standard, certainly not a medical or scientific standard. Again, I'll just point out again as well, this is 4 of the premature babies, 4 of 17. So there were 13 of the babies for which this didn't occur. So now we're dropping under 25% of the infants for which this occurred. So again, to infer any kind of meaningful pattern from this is ludicrous. In the case of 2 babies, another nurse was worried about them, but the defendant reassured them just before they fatally collapsed. So again, firstly, this is 2 out of 17 infants. So just from that alone, we cannot say it's a meaningful pattern. It's the kind of account that we heard from eyewitnesses on these cases must be called into question. I don't think we can definitively say that Lucy definitely did this. However, it's perfectly normal conduct for her to reassure the nurse. I mean, essentially, she's just trying to make the nurse feel better. It has nothing to do with the collapse. They're completely independent acts and absolutely unrelated. Also, logically, If Lucy had attacked the infants, it would make more sense for her to not reassure the nurse in question, because by reassuring the nurse in question then collapsing, you could say that looks more suspicious. It would be more logical for her to say, you're right, they're not looking very well, I'm concerned about this, and then they collapse. In this instance, once again, the prosecution case makes no sense. Of course, it's only for 2 of the 17 infants, so it's a load of crap in the first place. There were 7 babies who collapsed shortly after the parents had left the nursery. Again, highly debatable because of the very poor evidential basis on which this was asserted, the very poor evidential sources that were used to assert this. And then again, of course, it's 7 infants out of the 17 in the court case. It's still a very small minority. It can't be used for any kind of pattern or meaningful statistical inference yet again. Notice for all of these things that are being listed here, it's not on one occasion is it the majority. They'll just find a few common factors or what they deem to be common factors, and if they can't find common factors, they just fabricate the evidence. Then they say, oh look, we found a few infants where this happened, so it must be Lucy Letby. Absolute rubbish. It's complete crap. Again, 4 babies recovered quickly from collapses when they were taken to the hospitals. Firstly, there are so many things to say about this. Firstly, there can be numerous reasons why this occurs. We know this is a failing hospital, but even if it isn't a failing hospital, they should fare better on a tertiary unit. They're supposed to fare better on a tertiary unit. That's why it's a tertiary unit. That's the first thing. The second thing is, no one can possibly say what's going to happen with a vulnerable infant that is struggling to survive. Of course they can recover at another hospital, but then they may not. And indeed, the third thing to say is, other infants were transferred away from the County Chester and indeed died at other hospitals, which is regrettable, but it's something that happens to vulnerable infants. And again, yet again, this is 4 out of 17 infants, so less than 25% of the infants in the court case. So nothing that you can infer anything from or make any kind of statistical assertion regarding a pattern. I mean, this is, even for this court case, again, this is nonsense evidence. It's just essentially completely meaningless. And then these 3 cases where supposedly Lucy participated inappropriately in post-death bereavement procedures, except that we know from speaking to nurses that she wasn't inappropriate, although it should even be fairly clear from the court case that she didn't behave inappropriately. In today's video, sending a sympathy card is not inappropriate behaviour. Taking a photograph of a sympathy card that you've sent is not inappropriate behaviour. Attempting to comfort the parents is not inappropriate behaviour. Smiling, various aspects of her demeanour, nothing that was indicated is inappropriate behaviour. I could go on, but there were so many things mentioned, none of which are inappropriate. It's described here as participating inappropriately in post-death bereavement procedures. But nurses don't think that what she did was inappropriate. Nurses think that what she did was normal. It was the parents, having been prompted by Cheshire Police from day one that someone might have murdered their babies, and then they went around trying to gather information from them, having seeded them with this information, essentially. It's the parents that go on the witness box and say these things. Not any member of medical staff, not any nurse. So for the judge to present this as inappropriate behaviour is indicative of a theme that I'm going to discuss at the end of this video. And again, of course, it's 3 cases out of 17. There was one baby O who sustained an impact injury to his liver that on the pathological evidence was a consequence of the application of considerable force. So there have been 3 other pathologists who've now looked at this infant and they've all disagreed with what Marguerite has said. We obviously know basically what happened with this infant, so this is completely incorrect, simply. Again, the jury was just given what is incorrect medical information in the court case. The prosecution say that this is not a series of unconnected events. Well, it is. I mean, it's, if you look at the numbers of events that they group together, it quite obviously is utter tripe to say that they're connected in any way. There's not even one of those instances or one of those supposed connections that you can say occurs in the majority of cases. They're all in the minority of cases. So there's no way that you can assert that this is any kind of meaningful pattern. When put in the context of the expert and medical evidence, the administration of insulin, the finding of air in the great vessels in some babies, and the post-mortem evidence of Dr. Manrides and all of the other evidence, you can be sure that the defendant committed all the offences upon which you were trying her. So this particular statement here is indicative of something that you'll see legal types say quite a lot, which is, you've got to look at the evidence in the round. You've got to look at all the strands of evidence put together. And so if you put all those strands together, which has briefly been done here, then it could potentially look like a convincing case. It's just when you look at the individual strands, you see that they're not constructed of anything resembling any substance. So what looks like a decent circumstantial case falls apart very quickly because all of the strands are worthless. The defendant denies, again it's the word denies that I really object to, she committed any harmful act. She was, I repeat, hardworking, dedicated and caring. She never falsified records. So let me just emphasise with regards to this. The accusations regarding Lucy falsifying records in court were all completely fabricated. There's no evidence whatsoever that Lucy falsified records. All of the evidence, in fact, points to the fact that she was the most diligent compiler of Datex records on the unit. And so Judge Goss continues, and there is evidence of which you were reminded of other nurses failing to complete some entries on charts. Of course there were, because Lucy was the best nurse on the unit with regard to documentation. That is what Karen Rees said. Karen Rees is the most qualified person to comment. She worked very closely with Lucy and she was the nursing leader. So when she says Lucy's documentation is spot on, Lucy does everything by the book. Lucy's the creme de la creme. Lucy will datex herself when she makes mistakes, implying that other nurses don't do this. So it's not surprising that other nurses fail to complete entries on charts, but that's not a criticism of them. That happens all the time because nurses are under immense pressure. It's a really difficult job. They all end up staying back late and doing unpaid work. I mean, to actually cite this as being meaningful evidence, you'd have to... The only way this would be meaningful evidence would be if someone had seen this. If someone had seen Lucy falsify records, and you could have an eyewitness who stood up in court and said, I saw her changing a Datex account to something that I know to be incorrect, then it would be meaningful. Of course, in common with absolutely everything else in this court case, no one saw anything, no one suspected anything. This is just something that is fabricated by the prosecution. Her keeping of confidential documents, again, it's her keeping. She's not really keeping them. They're just stored under her bed because she hasn't thrown them away. She probably should have thrown them away. She probably should have taken them into work. I mean, she possibly even could have thrown them in the bin. She could have taken them to a landfill site. Or, I mean, I've even seen, even if you just throw them in the bin and they go straight in the back of a dustbin lorry, it's very unlikely anyone would ever been the wiser. But if you took them to a tip or something and just threw them away in a carrier bag, no one's ever going to find them. It'd be like that guy who lost his Bitcoin. Don't know if you've heard about that story. Who's supposedly thrown away tens of millions of pounds of Bitcoin and it's stuck in a landfill somewhere. And he wants permission to search the site, and the council won't give him permission. But the idea that these documents, she could have just lobbed them in a tip or something. If she did, obviously that's not very responsible, but no one ever would have found them. But the idea is that she was keeping them or storing them for some reason. Of course, it had, as Judge Goss says here, no sinister purpose. What could the sinister purpose possibly be? What possible reason could she have for deliberately taking home these documents and then keeping them, although she didn't keep them in any meaningful place? So of course it's not sinister. The fact that I have to keep discussing this, I'll probably discuss this about another 5,000 times in my life. Nor did her searches on Facebook, which have nothing to do with the case. Like the handover sheets, this is nothing to do with the case. It's nothing to do with the indictment. It's nothing to do with the infants. Nothing. Which she ultimately said in evidence she only made because she was thinking of the families at those times. Of course that's the reason. Of course it's the reason. It's a perfectly normal thing to do. Oh, what about those poor parents? Their infant died while I was on the unit. I wonder how they're doing. It's the kind of thing like a normal human being would do. I mean, I probably wouldn't look them up on Facebook because, I hate social media and I don't really understand how to use Facebook. But people that are more into it and more enjoy social media, they do look people up on Facebook and they do look stuff up on Twitter, etc., etc. So it's hardly abnormal behaviour, and it's hardly abnormal for a nurse who's cared for an infant who had notably good relationships with some of these parents to look them up to see if they're okay. It's hardly significant. The way that it was presented in court is it's some form of gloating or something, or that she's somehow celebrating her crimes, although she never actually writes anything down about her crimes anywhere, her supposed crimes. Ridiculous. Her handwritten notes were something she did as a habit and were a product of despair. I'm not going to dwell on that any further. I mean, that note has been completely discredited, and there's the blue post-it note that has exculpatory statements in it. I'm just not going to go talk about the notes any further at this point. I'll probably have to again in the future, but we all know the note has no merit as an item of evidence whatsoever. The defence say you cannot be sure that in any case she murdered a baby who died, or that she attempted to murder any baby who survived. Some of those babies were very premature and at high risk of sudden collapse. The evidence upon which the experts rely in relation to her embolus, they say, is based on theories and not well-established medical knowledge. There have been inconsistencies in accounts, and it is submitted the experts have lacked independence and reliability. Well, that is no more than the barest summary of the respective arguments, which, as you know, took a number of days because it's illegible in each, as far as each side was concerned, to put those arguments before you. Shortly it will be for you, on all the evidence that you have heard, to perform your task of reaching verdicts on the 22 alleged offences charged on each indictment. And those were literally the last words that Judge Goss uttered of any relevance, and this was the end of the Lucy Letby case. He did make some further instructions to the jurors regarding how they were supposed to retire and make their decision, various comments about breaks, but they're really not worth looking at. This was the last word of any substance in the Lucy Letby case. So, in summary, even in this relatively short snippet of the summing up, we see several themes. The first one is that Judge Goss has repeated prosecution arguments that we know to be incorrect. Secondly, Judge Goss has presented prosecution arguments which have no merit as being significant. The third one is that Judge Goss has effectively communicated nothing about any of the defence's challenging of the prosecution evidence and concepts. There was one very short section, but as you can see, the vast majority of this summing up was dedicated to discussing the prosecution case. This is consistent with the assertion that Goss discounted all the defence's cross-examination of witnesses. In these very final comments of the court case, he presents almost none of the defence's case. Ultimately, what needs to be understood here is that once something is presented in court, if it is not challenged, then it is placed on an almighty pedestal, even if it has no foundation whatsoever. As an example, someone could say in court that the moon is made out of cheese. If this is then not directly challenged, the moon is then legally made out of cheese, particularly if the person was convicted on the basis of the moon being made out of cheese. As Mervyn has noted in his most recent video, if you listen to or communicate with many, though not all I must emphasise, legal professionals, particularly barristers, you will soon find out how little they care about how ridiculous this is. So I'm sure they would defend a verdict in which someone claimed the moon was made out of cheese. Or while I was compiling this video, I was reminded of the episode of The Simpsons that is a parody of Lord of the Flies. And so what occurs in that episode is someone has stolen food. The children are stranded on an island as someone has stolen food. So you see this quite amusing scene where Nelson, who's like a bully at the school, is one of he's essentially the prosecuting barrister. So you see him striding backwards and forwards like this. Milhouse there is the defendant in the background. So he strides backwards and forward and looks very thoughtful. And then he just starts punching Milhouse and says, you did it, say you did it. Now, I would suggest that if this actually happened in a court case in Britain and someone was convicted, it wouldn't surprise me if, legal professionals defended it. If barristers, the gentleman who Mervyn is talking about in his video, would maybe treat it as a joke, as it's being suggested in the comments for that video. They're so desperate to defend the court system, to defend the legal system, to defend their process and procedures, that they just seem, as I say, things are put, once something has happened in a court, it's put on an almighty pedestal. So even as we continue to tear this court case apart, and we continue to look through it and see how ridiculous it is, how absurd it is, how it's not even like Swiss cheese. There is no cheese. there aren't even holes. There just is nothing of substance to cling to. There is no cheese to begin with. And then I just finally wanted to note, as a little amusing aspect of this, that in this Simpsons episode, Lisa, as an argument, says, "Did any one of you actually see Milhouse eat the food?" Now, unfortunately, Lisa, as we know now, that's not how things work in court. Finally, I'd just like to say that I'm going to be away for the next couple of days. So I'll try and answer some of your messages, but I'm going to be quite busy. But I'll try to answer some comments. I don't know what I'm going to do on the 16th, Sunday the 16th. I may post a video on that day, but I just wanted to say that I'm going to do a live stream on the evening of Sunday the 16th of November, starting at 7 p.m. UK time. I might do a post on this as well if I remember or get time, but I thought it'd be easier to include it on this video just to let you know that I'll be going live at 7 p.m. UK time on Sunday the 16th of November. So I hope to see some of you there. Otherwise, I'll just be talking to myself.